If you own a home and you were born in the 1940s, the 1950s, or the 1960s, there are property tax rules in place right now that are specifically tied to your birth decade. Not general housing rules, not general tax policy. Rules with age thresholds, deadlines, and benefit levels that change meaningfully depending on exactly how old you are right now. And what makes this so costly for so many people is not that the rules are complicated, it is that the rules are sitting there, in place, legally available, and almost nobody is using them because nobody explained that the rules work differently for different age groups. Here's the part that should catch your attention immediately. The most valuable benefits on this list, the ones that can reduce a property tax bill by thousands of dollars every year, are concentrated in a specific age range. And for people born in the 1940s, the window to claim the full benefit of the most generous version of these programs is getting shorter, not longer. Waiting is not neutral. Waiting costs money. This video goes through what the rules actually look like for each of the 3 birth decades, what the money looks like in real dollar terms, and what you need to do to claim every dollar that the law already says belongs to you. Before anything else, share this with someone you know who was born during any of these 3 decades and owns a home. A parent, a sibling, a neighbor, a friend who just retired. One conversation based on this information can save them more money than most people save in an entire year of couponing or budgeting. Share it now and then come back. Let us start with the foundation, because without understanding it, the specific rules for each decade will not make full sense. Property taxes in the United States are not set by the federal government. They are set at the state and county level. That means there is no single national rule that applies uniformly. What does apply broadly is the principle that nearly every state has adopted over the past few decades, which is that senior homeowners deserve some form of property tax relief based on their age, their income, or both. The specific structure varies, but the pattern is consistent. Age thresholds trigger different levels of benefit, and those thresholds were not created arbitrarily. They were set based on research about when housing cost burdens become most acute for homeowners on fixed retirement incomes. The critical thing to understand is that these benefits do not apply automatically. In almost every state, the homeowner has to apply. The county assessor's office does not look up which homeowners have crossed an age threshold and apply the benefit without being asked. The burden of application falls entirely on the homeowner. And because the programs are administered by counties rather than by a single national agency, they are not well publicized. The homeowner who never thought to ask is the homeowner who pays full rate indefinitely. Now let us go through each birth decade and talk about what the rules currently look like and why the specific age matters so much for each group. For homeowners born in the 1940s, the situation is the most immediately urgent of the 3 groups, and it is worth understanding why before getting into the specifics. If you were born in the 1940s, you are currently somewhere between 76 and 85 years old. You have almost certainly been eligible for senior property tax benefits for over a decade. The question is not whether these programs apply to you. The question is whether they are currently on your account and whether you are receiving the most generous version of the benefit that your age and circumstances qualify you for. Here is the specific issue that affects this age group more than the others. Many senior property tax exemption and freeze programs have tiered benefits that increase at different age thresholds. In some states, there is one benefit level at 65, a more generous level at 70, and the most generous level at 75. In several states, homeowners who have reached 75 or older qualify for either a higher dollar exemption, a broader income exclusion, or in some cases, a full deferral program that allows them to stop paying property taxes entirely until the home is sold, with the accumulated taxes becoming a lien on the property settled from the estate. Texas is one of the clearest examples of this tiered structure. For homeowners 65 and older, Texas provides an additional homestead exemption of $10,000 on the school district portion of the property tax bill, and a tax ceiling that freezes the school district tax at the dollar amount owed in the first year of eligibility. Homeowners do not need to be 75 or 80 to access this in Texas, but the ceiling only locks in from the year the homeowner applies, not retroactively. A homeowner who became eligible at 65 but did not apply until 80 has been paying an uncapped, potentially increasing school district tax for 15 years when they could have had it frozen. That is 15 years of increases that cannot be recovered. In Illinois, the senior homestead exemption provides a reduction of $8,000 in equalized assessed value for homeowners 65 and older. The senior assessment freeze, which is a separate application, locks in the assessed value at the level from the year of application for homeowners 65 and older who also meet income requirements. And there is a low-income senior citizens assessment freeze program that specifically targets homeowners with income below a defined threshold. Homeowners born in the 1940s who live in Illinois and have not confirmed that all three of these programs are active on their account may be significantly overpaying. The action step for homeowners born in the 1940s is to call the county assessor's office, provide their birth year and property address, and ask specifically which senior property tax exemptions are currently active on this account, and are there any age-based tiers that would qualify this property for a higher level of benefit than what is currently applied. The answer to that question may result in an immediate reduction in the current year's tax bill and potentially a retroactive correction depending on state law. For homeowners born in the 1950s, the situation is different in a specific and important way. This group is straddling one of the most consequential thresholds in the entire senior property tax system, which is the age 65 cutoff that triggers access to most state senior exemption programs. If you were born in the 1950s, you are currently somewhere between 66 and 75 years old. If you are over 65, you became eligible for most senior property tax programs sometime in the past decade. The question for this group is both whether those programs are on the account and, for those who are closer to 65 than to 75, whether they applied promptly after becoming eligible or whether they missed years of benefit by not knowing the application was required. Here is a number that illustrates why the application date matters so much. In Florida, the senior homestead exemption can add an additional $25,000 in value reduction for qualified homeowners 65 and older. For a home assessed at $400,000 in a county with a 1% effective tax rate, that is $250 per year in reduced property taxes just from that one additional exemption, stacked on top of the basic $50,000 homestead exemption. Over the last 10 years, a homeowner who was eligible but never applied has paid an unnecessary $2,500 in property taxes. That money is gone. The retroactive recovery rules in Florida do not allow for recovery of prior overpayments. They only go forward from the year of application. For homeowners in the 1950s birth range who live in states with income-tested exemptions, there is an additional consideration. Income thresholds for many of these programs were set years ago and have not been adjusted proportionally for inflation. What was a middle-class income when those thresholds were written may look different relative to the current cost of living. Many homeowners in this age range who genuinely believe they earn too much to qualify are above thresholds that were designed decades ago, not above what the programs actually require today. Calling the assessor's office to ask for the current income threshold, and then actually checking whether current income falls within it, is worth doing even for homeowners who assumed they would not qualify. The freezing programs matter especially for this group. A homeowner born in 1958 who is 67 years old today and who lives in a state with an assessment freeze program has an opportunity to lock in the current assessed value of their home at a moment when property values in many markets have plateaued or begun to correct from recent peaks. If values rise again in coming years, that freeze becomes dramatically more valuable over time. The window to lock in a favorable baseline is open right now for many homeowners in this age range, and it gets more important, not less, as time passes. For homeowners born in the 1960s, the picture is different again, and the urgency here is about preparation rather than immediate application. If you were born in the 1960s, you are currently somewhere between 56 and 65 years old. If you have not yet reached 65, most senior property tax exemption programs are not yet available to you. The 65 threshold is the most common cutoff, and most states have not moved it significantly in recent years, despite pressure from advocacy groups to lower it. But there is still a reason why homeowners born in the 1960s need to understand these rules now, and it is this. The homestead exemption, which is distinct from the senior exemption, is available in most states to any primary homeowner, regardless of age. And the homestead exemption is the foundation on top of which the senior exemption is added later. Many homeowners, including those in their 50s and early 60s, have never filed for the basic homestead exemption because nobody told them it was not automatic. In states where the homestead exemption is not automatic and requires an application, A homeowner in their late 50s who has lived in their home for 10 years without ever filing the homestead exemption application has been paying the full assessed tax rate for a decade. When they turn 65 and learn about the senior exemption, they may apply for it without ever realizing that the base exemption beneath it was also missing. They end up with one exemption, but not both, and their bill is still higher than it should be. The Texas homestead exemption provides a $3,000 reduction in assessed value for the school district tax on any owner-occupied primary residence. It also caps the increase in the home's taxable value to no more than 10% per year, regardless of how fast the actual market value rises. That 10% cap is one of the most valuable provisions in the Texas homestead exemption, and it compounds dramatically in a rising market. A homeowner whose home value rose 20% in a year pays school district taxes as if it only rose 10%. A homeowner who never filed the homestead exemption pays taxes on the full 20% increase. For homeowners in the 1960s who live in California, the situation is different. California's Proposition 13, passed in 1947, caps property tax increases at 2% per year, regardless of how fast market values rise, as long as the homeowner does not trigger a reassessment event. In California, the homestead exemption provides a relatively modest reduction in assessed value, but the Proposition 13 protection itself is one of the most powerful property tax protections in the country for long-term owners. However, California voters approved Proposition 19 in 2020, which changed the rules for how the Proposition 13 base year value can be transferred between properties and between generations. For California homeowners born in the 1960s who are thinking ahead to either downsizing or passing the home to children, understanding the current Proposition 19 rules before acting is essential, because the rules for intergenerational transfers changed significantly. Now let us talk about the circuit breaker, which is a separate type of property tax relief that most people have never heard of, and that is particularly valuable for homeowners in all 3 birth decades whose property taxes represent a high percentage of their income. A circuit breaker program, which exists in some form in roughly half of U.S. states, limits the amount of income that can be taken by property taxes. The name comes from the electrical circuit breaker that trips when the load becomes too heavy. When a homeowner's property taxes exceed a defined percentage of their income, the circuit breaker provides relief in the form of a credit or a direct payment that reduces the effective tax burden. Wisconsin is an example of a state with a circuit breaker program. The homestead credit in Wisconsin provides a tax benefit when property taxes or rent exceed a certain percentage of income, up to a maximum credit that declines as income rises. The program is available to all homeowners meeting income requirements, but seniors over 62 receive a higher maximum credit than younger homeowners. Michigan has a homestead property tax credit that provides a credit on the state income tax return for homeowners whose property taxes exceed 3.5% of their household income, up to a maximum credit of $1,500 per year. For a homeowner on a fixed retirement income of $30,000 per year, if their property tax bill exceeds $1,050, they may be eligible for some level of credit through this program. The important thing to understand about circuit breakers is that they are often claimed through the state income tax return rather than through the county assessor's office. That means a homeowner who thinks they have checked all the boxes at the county level may still be leaving circuit breaker relief on the table because the program requires a different filing in a different place. Now let us talk about what the accumulated unclaimed benefit looks like in real dollar terms, because the numbers are large enough to warrant serious attention. Consider a homeowner in Illinois, born in 1952, who owns a home assessed at $250,000 in a county with an effective property tax rate of 2% per year. Their annual property tax bill without any exemptions is $5,000. If this homeowner had applied for all 3 available programs, the general homestead exemption reduces assessed value by $10,000, saving $200 per year. The senior homestead exemption reduces assessed value by an additional $8,000, saving $160 per year. The senior assessment freeze locks in the assessed value at its current level, preventing future increases that could add hundreds of dollars per year as values rise. In aggregate, these 3 programs, combined with the freeze, can reduce the current bill by $360 per year and protect against future increases that, in a rising market, could compound to thousands of dollars over a decade. If this homeowner became eligible at 65 and is now 73, they have been missing 8 years of these benefits. 8 years at $360 per year is $2,880 in overpayment that they cannot recover. The assessment freeze that would have locked in the value 8 years ago is now locking in a higher number than it would have then, meaning the freeze, while still valuable, is less valuable than it would have been if applied promptly. That is the cost of not knowing. And that cost is sitting in the accounts of millions of homeowners across this country right now. Here is the most direct action list available from everything covered in this video. First, find out your county assessor's phone number or website address. Search your county name followed by property tax exemption or senior property tax relief. Most county assessors have this information posted online. If the website is difficult to navigate, call. County assessor offices are accustomed to answering these questions and can usually tell you in one conversation what programs exist, what you qualify for, and what documentation to bring. Second, ask specifically about each of the following by name: the homestead exemption, the senior or age 65 exemption, the senior assessment freeze, and any circuit breaker or income-based relief programs. Ask whether there is a tiered benefit based on age, and ask what the income thresholds are for any income-tested programs. Third, bring to the appointment or have ready for the call proof of age, which is typically a driver's license or passport, proof that the property is the primary residence, which is typically a utility bill or voter registration, and if income-based programs are involved, the first page of the most recent federal tax return. Fourth, if you are in one of the community property states and your home has increased significantly in value, ask your county assessor specifically whether California's Proposition 19 rules, or your state's equivalent, affect how the exemption interacts with any planned transfer of the property. Fifth, once the county applications are complete, check your state income tax filing for any circuit breaker credits that may be available. If the most recent return was filed without these credits and you have overpaid, amending is possible in most states within 3 years. The cost of not knowing these rules is not abstract. It is a real dollar amount, leaving real household budgets every year. For homeowners born in the 1940s, the action is to confirm that all age-tiered benefits are currently applied and to check for deferral programs. For homeowners born in the 1950s, the action is to confirm that both the base homestead exemption and the senior exemption are on the account, and to investigate the assessment freeze. For homeowners born in the 1960s, the action is to make sure the base homestead exemption is filed, and to start learning the senior rules well before the 65 threshold arrives, so that the application is ready the moment it becomes eligible. None of this requires an attorney or a financial advisor. It requires a phone call or a visit to a county office in about an hour of time. This video is for educational purposes only. The information shared here reflects general knowledge gathered from publicly available sources, including YouTube, Google, news media, and other publicly available resources, and represents personal opinion only. It is not legal, financial, or tax advice for any individual situation. Property tax exemption rules, income thresholds, application deadlines, and benefit levels vary significantly by state and county, and may have changed since this information was compiled. Always confirm the specific rules, current thresholds, and application procedures directly with your county assessor's office or a qualified tax professional before taking any action based on the information in this video.